labor law update. Today sponsored by Riverside County. My name is Anna Manzano, and I'm the digital media and event strategist here at the California Employers Association. And we just want to thank you all again, as Eli said, for taking time out of your lunch hour to join us. So before we get into today's training, I have just a couple details to go over with you. So as you see, your audio is muted for today's presentation, but there's going to be lots of opportunities to engage during today's training. You're already doing so wonderfully in the chat, so keep that up for us today. We have 90 minutes together. So if you do have any questions during the training, you can enter those into the Q&A box at any time. If you're joining us on a desktop computer, it's going to be along the bottom row of Zoom. You'll see that Q&A. That's going to be the best place to put your questions. So while one trainer is delivering the content, we'll have another trainer managing that Q&A. About the halfway mark, they'll go ahead and switch. So you will be well taken care of with all your questions today. Handouts for this training were sent out in yesterday's reminder email. I will also be dropping that PDF into the chat box shortly. So once you see a little logo and the file name pop up, if you just click on it, it'll download locally to your drive. And I will be monitoring that chat box. So if you have any issues accessing that file, you can just go ahead and ping me. I'll make sure I get it over to you one way or another. Again, this webinar is being recorded, as you saw, and so the team at Riverside County will notify you all when the recording will be available for playback. So make sure you are actively on their email list and looking for that, and they'll notify you when you can watch the recording. Last but not least, we do have a survey. It is a very brief 5-question survey. It generally takes less than a minute to complete, but the feedback that you share with us, we then share with our partners over at Riverside, and we just collectively make sure that we are meeting and hopefully exceeding your expectations with trainings like this, as well as the entire suite of resources available to employers like yourself. So at the end of today's training, you'll see a slide with a QR code. Also, when you click out of Zoom, a browser window should pop up, and there'll be an invitation. All you have to do is click opt in. So you can choose your own adventure. But we would love if you would take a minute and share your feedback with us so that we can better serve you. So again, our training today is brought to you by our partners over at Riverside County. And today we are so happy to be joined by Jason Tang, who is the development manager there, who is going to share more about the resources available to employers like yourself. Hi, Jason. He may be frozen. Let's see.
He may have frozen up on us.
So let's see if we.
Well, looks like everybody. There we go.
I am having some internet problems. Can you guys hear me?
Yes.
No, we can.
Okay,
yes.
I'm so sorry. But thank you, Anna, and welcome to our first webinar of 2025, everyone. We appreciate everyone taking the time out of your schedule to attend this webinar. It's always one of our most popular topics, the labor law update. But and certainly with the new administration coming in, there are many more changes that will surely come down the pipeline. So be sure to watch out for the other webinars that we'll be hosting this year as we continue forward. Also, our HR Hotline, which you see on your screen. Now, that is a free HR hotline for businesses to use. You can get assistance with any of your HR questions. It's free. And so it's just a way that we are serving the business community here in Riverside County. So we encourage you to use that. It's a wonderful resource, and they're always very helpful. Ever need any other type of workforce assistance, please reach out to us directly and we'd be happy to help. Thank you, Anna.
Awesome. Thank you, Jason, and your entire team behind the scenes for all the work you do for your employers in Riverside. I'm going to have Jason also put his direct contact information into the chat box so that you have a way to contact their team with any of additional needs and resources. And so now I'd like to introduce our trainers today, who, if you did have called the hotline before, maybe you've had the pleasure of working with them directly. But today we have two of our HR directors, Eli Nunez and Astrid Servin. So you are in really good hands. So Eli, I'll kick it over to you.
Thank you very much, Anna. Thank you very much, Jason, for the introduction. Again, I'd like to remind you all, we do have that hotline available for you. Give us a call Monday through Friday from 8 to 5. Sorry, not on holidays. We do take some time off here and there, but we always love to hear from our Riverside County employers with any questions, whether it's about, hiring, firing, sick leave, new changes, or if you just have a situation with your employees that you just want to talk through and, sound it out with somebody, we'd love to hear from you. We'd love to talk about it and help in any way that we can. A little bit more about us. We are the California Employers Association, which, our goal is to provide employers with peace of mind. We know that things change really fast in the state of California and federally as well. It's been an interesting month to say the least, but we are here to provide that peace of mind with trainings such as these, providing some guidance and information through the hotline. Anything you need from the HR side, we'd like to provide that for you, kind of help to ease that burden a little bit. We know it's very complicated, especially in the state, so we are here to help. Having said that, though, I must say that we are not lawyers. Astrid's not a lawyer. I'm definitely not a lawyer. And even though we do have people on our team with legal experience, we do not provide legal advice. So this training or any advice that we give will present you with information, maybe some of the options available to you, touch on some of the guidance or some of the requirements, but we do not give legal advice. We always do advise if you have any question of legal nature, please contact your attorney so they can better assist you in that situation. Now that we got the fine print out of the way, let's jump right into the presentation. So some of the things we'll be covering today, of course, wage and hour. Early part of the year, we always know that there's changes to wage and hour, whether it's minimum wages or reforms or anything like that. So we'll be discussing some of the hot topics there. We'll talk about some changes to employee rights. What are some of the new laws and new protections for employees? Then I'll hand it off to Astrid, where she'll talk to you about changes in leaves and benefits in the state of California, things that are new or things to look out for this year, along with some changes to safety and some employer-specific rules. So things for certain industries or certain employers that they have to look out for this year. So to start off, of course, we'll start off with our wage and hour updates for the year. And the biggest thing, of course, is we've gotten used to the past couple of years is the minimum wage increase in the state of California. So as you recall, back when Governor Jerry Brown was in charge, there was a law signed into place that said any time inflation or the consumer price index is beyond a certain point, it will automatically trigger a minimum wage increase. Well, as we know, I mean, things weren't exactly rocking and rolling too much last year, so it triggered another increase for us this year. So as of January 1st, the statewide minimum wage is $16.50 for non-exempt hourly employees. That's for all employers, regardless of size. Some of you have been in business for a couple of years. Remember a few years back that it was kind of a tiered system where if you were a smaller employer, you had a lower minimum wage versus a larger employer. That's all gone now across the state. The minimum wage is now $16.50. And as you know, whenever that non-exempt or hourly minimum wage changes, it also has an effect, a ripple effect that affects the exempt or salary minimum compensation in the state of California. So in this case, the minimum exempt salary in order for an employee to maintain their exemption has increased to $68,640 per year. How do we come up with that number? Well, we took that $16.50, multiplied by 2,080 hours, which is the equivalent of a 40-hour work week throughout the year, and then we doubled that to come up with 68,640, meaning that the exempt salary is 2 times the hourly minimum wage. Now, if you find yourself in a situation where you have an exempt employee that is, just below that, or that increase hits, and you don't know if you can afford to give that increase to them, or you don't want to, or whatever the case, then you can always transition them back from an exempt employee to a non-exempt. In the state of California, all employees default to non-exempt, so they are subject to that hourly minimum wage, along with meal and rest break protections, overtime, etc., etc. So it is an easier transition to go that way, to go from exempt to non-exempt. Having said that, even though it's easier, doesn't mean it's not without its difficulties. Some employees may consider it almost like a demotion, or may have to get used to clocking in and out again, or clocking out for lunch, or what have you. So we have created some tips for employers to use when they're transitioning employees to non-exempt from exempt. Of course, there's some practical things to look for, along with some employee relations tips if you find yourself in that situation. Now, along with the state minimum wage, there's also local minimum wages that change throughout the state. Being in Riverside, you are close to other metropolitan areas, so you know that sometimes the minimum wage or even the paid sick leave laws can be a little different. Up here in Northern California, we're very close to the Bay Area, and there's a lot of municipalities, cities, or counties that have different minimum wages as well, or different paid sick leave protections. So As of last count, there is over 40 local ordinances that could apply as far as a higher minimum wage than what the state requires. And that's important to keep in mind because if you have any employees that work remotely and live in one of these areas or work out of one of these areas, you have to be aware of any additional wage or salary protections available there. By the same token, if you're in an industry where your employees travel to these areas, so for instance, construction, landscaping, housekeeping, um, caring for people, that sort of thing. If they travel and perform work in these areas with the higher minimum wage or the additional paid sick leave, predictive scheduling, or flex time protections, you have to be aware of what those are because they could apply to the employees because as the slide says, the local minimum wage is based on where the employee is physically working. So if it's a remote employee, it's their home residence, or if they're traveling somewhere to do work, then it is where they are traveling to. Again, keep an eye out for those increases. There's usually an increase at the beginning of the year to keep up with the state's minimum wage increase. And there's also one usually right around July 1st, right around mid-year. There tend to be some more increases there. Every once in a while, I think it was last year, 2 years ago, one of the counties up here in Northern California did the increases a month before everybody else. Maybe it was just to be different, or maybe they had some other financial stuff going on. Whatever the case, just keep an eye out for that. We do have a link there where you can visit a page that keeps up with those minimum wages for you. So if you have employees in these areas, again, keep up with those changes and make sure you're compliant. Something else that garnered a lot of attention last year was the minimum wage for fast food workers. And this applied to any chain with over 60 locations nationally that served any fast food or that sort of thing. Now, what happened was there was a council created that could advise on things like, minimum wage, working conditions, that sort of thing, and they can also give advice for wage increase throughout the year. Now, there was no increase on January 1st of this year, but again, this is another one to keep an eye on because this came into effect April 1st of last year, so there may be another increase coming around either spring or summer of this year. We've not heard anything either way, but again, this fast food council can advise that, so be aware of it if you're in that industry, if you're affected by it. Something else that came of this too is since there is a higher hourly minimum wage, the DIR clarified that the exempt minimum wage for fast food employees who are exempt and who are fall under these protections also increases beyond what the state requires. So in this case, if you double that $20 an hour and multiply it by 2,080 hours per year, that comes up to $83,200 per year. So if you are in one of these chains that falls under this fast food minimum wage and you have exempt employees, those exempt employees must earn a minimum of $83,200 per year. Quite the leap from the state minimum wage. Another industry that we saw has its own minimum wage change last year was the healthcare industry. And now, this doesn't apply to healthcare across the board. There are certain requirements that you can take a look at. We have some guidance for that on our website, either through blogs or the state of California offers some guidance too to see if this applies to you or to what level this applies to you. Now, this finally came into effect on October 16th of last year. It was first slated to go into effect in late spring, early summer, but due to the financial situation in the state, it was delayed till the end or towards the end of the year. The goal for this minimum wage for healthcare is to have healthcare workers earn $25 per hour. But again, this is not being done all at once. It's a tiered approach. So there's ranges depending on your organization and where you fall into those ranges. It can be between 18 to $23 per hour. There is an increase expected June 1st of this year, again, just to maintain that pace to get up to $25 per hour. So again, the first thing is to see, which tier you fall under, and then take a look to see what it's going to look like again on June 1st. Since the hourly or non-exempt minimum wage is different for this. Again, it also has that ripple effect for exempt employees. So this law states that exempt employees have to be paid either 1.5 times the healthcare minimum wage that applies to their organization, or 2 times California's minimum wage, which is that $68,000 number we discussed earlier, whichever is greater. So again, if you find yourself in a situation where the healthcare minimum wage applies to you, so you have a higher hourly minimum wage, take a look to see what that calculates out to for your exempt employees to make sure you are paying them correctly. Now, speaking of exempt employees, there are a lot of exemptions in the state of California. And there's a couple that changed this year as well. Now, the one for physicians and surgeons, they do have their own minimum hourly pay. It used to be $101.22 per hour. That has increased to $103.75 per hour as of the first of this year. So again, if you are in the medical field and you have those physicians or surgeons working for your organization, make sure that that minimum wage is, or that minimum hourly pay is correct for them. The other one applies to computer software professionals. Now, this one is kind of a three-part one. They have a minimum hourly, minimum monthly salary, and minimum annual salary for them. So you have to make sure that they meet all three of those if you have computer software professionals employed for you now. Be careful with this one because a lot of times we hear about the computer exemption or the computer worker exemption, and a lot of people think that maybe their IT worker, the person that, runs cords for them, or maybe that sets up new computer systems or new computer stations falls under this. This computer software professional is specifically for those that are working on computer software, either creating new software, developers, that sort of thing. So again, take a look at the exemption to see if it applies to your employees or not. Okay, moving along to another one. This was another one that was probably expected. That is the mileage rate for personal vehicle usage. So if you have employees that use their personal vehicle for work or for work duties or whatever it is, then the rate of that we pay them per mile has increased now. Until the end of last year, it was 67 cents per mile, and as of January 1st of this year, it has increased to 70 cents per mile. This rate is set or established by the IRS, and they take into account things like fuel expenses, wear and tear on the vehicle, insurance, that sort of thing. So keep in mind if you have hourly employees that drive for you, you're going to pay them that 70 cents per mile for any mile driven, plus you're still going to pay them their wages. So again, that 70 cents per mile only covers the vehicle, the use of the vehicle itself. It does not cover the employee wages. Now, as employers, we can choose to pay something different than that 70 cents per mile. Obviously, if you want to pay more, that's easier, right? Because basically the IRS just gives us the floor. It says anything above this is fine. If you choose to pay anything below 70 cents a mile, then it is up to you to prove why that amount is adequate for the mileage rate. So again, if you have a good team of accountants or you have a really good you know, reason or argument as to why you should pay less than 70 cents per mile, make sure you have that ready because if there's any kind of complaint or claim, it will be up to you to prove why that is the adequate amount. So best practice, best advice we usually give is, that 70 cents per mile that's established by the IRS. That is the safest way to go. Now, saw a question pop up. Does the mileage reimbursement apply when employees attend trainings on behalf of the business that require travel? Basically, if they are doing anything under your control, if you're instructing them to drive to a train, if you're instructing them to drive to pick something up, if you're basically giving them direction to do something where they have to use their own vehicle, you have to compensate them for that usage. So, all right. The big news, or some of the big news for this year, is the PAGA reform. Now, for those of you that have heard of PAGA, it's something that, from what I hear, tends to send shivers down employers' spines, right? What PAGA is short for the Private Attorney General Act. So, what this means is that employees, I'm sorry, can or their attorneys can sue employers for labor code violations. So basically, PAGA allows private attorneys or employees to step into the shoes of the state of California and sue employers for labor code violations. Now, usually these things come about whenever there is any kind of wage and hour class action. That's what we hear about a lot whenever there's a PAGA suit or that sort of thing. And it's basically just just the state deputizing, if you will, private attorneys or employees to um, basically sue on their behalf to have that happen. Now, PAGA, I mean, this Private Attorney General Act started back in 2004, And once it started, it basically those claims skyrocketed to the point where a lot of businesses were saying, we're being crippled by this. Especially small businesses are saying, if we get hit by a PAGA lawsuit, that's lock the doors, turn out the lights, the party's over. We can't, we may not be able to survive it. So there was a big move to completely eliminate PAGA altogether, and there was even some kind of movement where some laws were going to be proposed to eliminate PAGA this year. That didn't happen. Instead, we had AB 2288 and SB 92 come across, kind of like a deal between labor or between employer groups and lawmakers to maintain PAGA, but to reform it, right? So these reforms apply to any case that was filed after June 19th of 2024. It's not retroactive to existing cases or anything that was filed before then. And really, it's important because it changes the way that these cases are litigated moving forward from that point. Right? So what it does is it gives employers the chance to reduce their penalties by showing that they're trying to do the right thing, by showing that they're taking reasonable steps to comply with wage and hour laws. Everybody makes mistakes. The state recognizes that. We recognize that. So what the state wants to see is that employers are taking steps to help either prevent or mitigate those mistakes when things happen. So this kind of an opportunity for employers to cure things or to fix things once they get the PAGA notice or even beforehand. So some of the reasonable steps that were identified that employers can take are having payroll audits, auditing your payroll on a regular basis, periodically, whether it's once a year, once a quarter, whatever it is. Just take a look at your payroll to make sure people are being paid correctly. Make sure your pay statements have all the correct information on them. Make sure basically that there's not any mistakes on there. And if you find any mistakes on there, make sure that you're taking action to correct them. The other one is make sure you have written policies in place to prevent any wage and hour or other violations. Train your supervisors on them. As we know, if we're business owners, we know sometimes our supervisors, our leads, our foremen may have the best intentions, but sometimes they make missteps, and those things kind of run uphill and get us in trouble, right? So make sure you train your supervisors on their responsibilities, on employee rights, on wage and hour issues to make sure that they're not either purposely or inadvertently violating any laws and getting you in trouble. And last one is taking corrective action if supervisors are not following your policies. So if you have any supervisors that are violating your policies, doing wage and hour violations, that sort of thing, make sure that you're taking corrective action, appropriate and timely corrective action. That's something that you can show that you're doing to eliminate the issue or to take care of the issue so those violations stop. We do have a wage and hour audit package that we've created that can help you for those payroll audits I mentioned, available on our store at employers.org. So if you've never done a payroll audit or a wage and hour audit, sorry, and you're looking for some guidance on it, we do have that wage and hour audit package that can help. All right, moving on from PAGA, we'll talk a little bit about changes to independent contractors this year. Now, these were not really eliminating anything, but really it was more extending protections to what are called freelance workers in the state of California. And SB 988 is actually called the Freelance Worker Protection Act. So this applies to freelance workers who provide services as independent contractors. So if you have a freelance worker that you hire on and put them on your payroll, they're not they're not independent contractors anymore. They're employees. But if you're just hiring them on to, perform a certain task for you or something you don't do on a regular basis, that these protections would apply to them. So doesn't change the test for an independent contractor versus employee. That still stands, but really it just extends those independent contractor protections to freelance workers who are basically one-man shows, right? There's just a one person performing, specific things for you, and basically it's like a one-man show, right? And it's just protecting them for it. So some of the requirements under SB 988 is now to hire a freelance worker, there has to be a written contract. And again, you can see all the requirements there: name and mailing address, list of services, rate, method of compensation, et cetera, et cetera. So basically the same type of written contract you would have if you're hiring a subcontractor, that's going to expand to freelance workers now. And also offer some protections where you can't reduce compensation, you know, ask for additional work beyond what's on the contract, or retaliate against those freelance workers. Now, they are not, those protections are not available now. I've tossed freelance worker or freelance, freelancer around a lot. So some of the services that are covered or that could apply as freelance workers are things like marketing, HR admins, travel agents, fine arts, grant writers, estheticians, certain appraisers or professional foresters, that sort of thing. I have a full list of the services that are covered under SB 988 as freelance workers. So again, make sure if you do contract out with individuals to perform certain tasks for you, make sure that you're following that guidance. So when it comes to wage an hour, here's your to-do list, things to make sure that we're doing. Make sure that you adjust your minimum wage, right? Make sure you're paying people correctly, whether it's hourly, non-exempt, or exempt employees. If you do have to change the rate for your hourly employees, make sure you're documenting that. So you could do that with updated those wage step notices that we usually give all our new hires. You can issue those out to your non-exempt hourly employees whenever you change their wages as well. And take a look at those local ordinances. If you have remote employees or if you travel to these areas or if you're one of these areas, make sure that you are compliant with those. And then take a look at your exempt employees too. Make sure that their salary is adequate. And, if it's not, then decide, are you going to increase their salary or are you going to convert them to non-exempt? Now, as far as the PAGA reform, make sure you're taking reasonable steps to identify and eliminate any wage and hour violations. So that could be things like payroll audits, wage and hour training for your supervisors, whatever it is. Make sure you're taking those reasonable steps, documenting them, having them ready in case you ever find yourself in the position where you have to defend a PAGA claim. You can show that you're taking some steps to help prevent that or to help mitigate it. And finally, those freelance workers, if you work with independent contractors, take a look at your independent contractor agreements, your arrangements, your contracts. Make sure that you have all the appropriate information on there. And again, anytime you are working with an independent contractor, make sure that they truly are an independent contractor and may not and could not be classified as employees, because misclassifying somebody as a contractor where they should be employees can be a very expensive mistake. And again, I'd like to remind you, we do have that wage and hour audit package available. You can take a look at our store. There's a bit.ly link there, or just go on our website to take a look. Let's talk about some changes to employee rights and protections in the state of California. And the big news for this actually came from the federal government. The EEOC basically updated their guidance on harassment in the workplace. And the way they updated is they didn't rewrite any laws or anything, but they gave us 77 new examples and clarifications of what constitutes harassment in the workplace. And some of these include things like intrusive questions about sexual orientation, gender identity, gender transition, or intimate body parts. Asking an employee, a coworker, a contractor, anybody, these kinds of questions can be a form of harassment. Harassment of the LGBTQ plus workers can include denial of access to bathrooms consisting with gender identity or intentional and repeated misgendering. So again, just because you see, pundits doing or celebrities doing it or actors doing it or, politicians misgendering people or denying access to bathrooms consistent with a gender identity does not make it legal. Remind your employees of this, please. Denying access to bathrooms consistent with gender identity or misgendering somebody is a form of harassment and has been identified as such by the EEOC. Harassment, they also clarify harassment can be based on medical conditions related to childbirth or pregnancy or the childbirth or pregnancy itself. Um, Finally, a mention of harassment occurring in remote work environments. And remote work, as we know, has basically exploded a few years ago with during the COVID era, if you will. So we know that working online, either talking over the phone or work in a virtual environment, sometimes people reduce their inhibitions, if you will, or say things that they shouldn't. So again, this is just a reminder that a remote work environment is not an excuse for harassing or discriminatory behavior. And the EOC also introduced the concept of intersectional harassment, which means that harassment can be based on more than one characteristic of an employee. So, for example, you can harass somebody based on both their race and their age, right? It doesn't have to be one or the other, it could be a combination of both. And we do have an example of what this looks like here. So, the example the EOC gave was one day at work, Janet, who was age 51, quickly removed her jacket and began fanning herself. A manager saw her and said, "Oh, you're having the hot flash. You must be menopausal." Janet said she would prefer not to discuss it. On another occasion, when Janet mixed up a customer order, the manager yelled at her and asked if Janet's mistake was because of all the hormones and said, "Women your age get so emotional." I think we can agree in this example that the manager was, well, one, rude for starters, but two, I mean, this was harassment and intersectional harassment because it was based on both the age and the gender of Janet. So again, he was making comments about her age, but also, talking about her hot flash, talking about her being menopausal, talking about her hormones, talking about her being a woman that gets so emotional, that sort of thing. So there's an example of two different protected classes being used in one episode of harassment. So again, I mentioned that the EOC, that was the federal government. FIHA also stepped up and clarified uh, intersectionality in SB 1137. So basically, what they stated was that unlawful discrimination or harassment can occur because an employee is not just in one protected class, but it could be a combination of two or more. Um, this was nothing new. Basically, it was just clarifying what's already existing and basically clarifying California law to be consistent with the guidance that the EEOC put out in April of last year. So things to do with this, maybe asking, well, that's great information. What do we do now? Well, take a look at your handbook, take a look at your harassment and discrimination policies to make sure that they're up to date and to make sure that they also address the concept of intersectionality within them. Okay. And of course, make sure you're doing your training every 2 years and reminding employees what is correct to do at work and what is not. Okay, another change to protected classes was AB 1815. And this, again, this basically changed an existing law or existing definition already. This applies to protected hairstyles. Basically deleted the word historically from the definition of race. So the old, guide used to say race includes traits historically associated with race, including but not limited to hair texture and protective hairstyles. We eliminated historically. So basically now it just includes traits associated with race, including but not limited to hair texture and protective hairstyles. Again, eliminated one word, but what this means is we have to go back, take a look at our handbook, take a look at our existing policies, and make sure that they read correctly. Eliminate historically from your protected class definition in there. Okay, moving along with employee protections, we have SB 1100, and this one deals with discriminating against employees or potential employees due to them either having or not having a driver's license. And what SB 1100 says is that we cannot require a driver's license from a candidate or an employee, whether it's in a job advertisement, posting application, or any other material, unless they need a driver's license to perform their job. I mean, it's as simple as that, I guess. So if the expectation is that driving will be a function of the position, so in other words, if you're hiring a delivery driver or a bus driver or whatever it is, chances are they're going to need a driver's license. And if you believe that alternative transportation will not be comparable in travel time or cost. So, for example, us directors of HR here at CEA, we travel to employee sites throughout the state, either for on-site trainings, investigations to help with other issues, right? And as you know, the state of California is not a small state. So sometimes, for instance, I'll travel from places like from Sacramento down to Fresno, down to the Bay Area or whatever it is, places where taking a cab or taking an Uber would really not be a reasonable alternative mode of transport for me. So in this case, we can say, since you are going to be going on site, you're going to travel throughout the state, you need to have a driver's license. So The important thing to do with this is take a look at your job applications, take a look at your job descriptions, take a look at your job postings, and if you have a requirement to have a driver's license on there, make sure that it is truly necessary. It's not just something that was, pre-existing or thrown in there or that'd be nice to have or whatever, and you just left it in there all this time. So again, take a look at them, update your job postings and application materials, and if it doesn't need to be there, it doesn't belong, make sure you remove it. Okay, our next change to employee protections is SB 399, and this dealt with captive audience meetings. Now, this is called the California Worker Freedom from Employer Intimidation Act. If you're not familiar with captive audience meetings, that means it is like a mandatory meeting that the employer calls for their employees, where failure to show up by the employee could result in some kind of corrective action. And a lot of times these meetings were held for things like union avoidance, for example, where the employer would talk about, you know, why employees should not join the union, why employees should not do this, why employees should not do that, right? Well, this act extended it to things like employer giving their opinion about religious or political matters, labor organizations, again, for example, and it dealt with, to protect employees from any kind of adverse action or threats of adverse action if they did not, um, go to these meetings. Now, this doesn't include mandatory meetings for information required to do their job. So, for example, if you're having a mandatory training on new software, new equipment, safety, whatever it is, those you can still require your employees to attend. But this really extends to anything where the employer is basically sharing their opinion about religious or political matters. So, what this means is that if you are going to have those meetings and you do want to have those meetings, then the employee has the option to not attend without any retaliation or repercussion, and they must be paid for the time they would have been paid for attending the meeting. So, as you can expect, I mean, there's been legal challenges to this already. Employers are saying that this basically is a violation of their First Amendment right, et cetera, et cetera. Whatever it is, we'll let the court decide that. But for the time being, this is still in place. And I mean, this extends all the way to the federal level. The National Labor Relations Act does, or I'm sorry, the National Labor Relations Board ruled that mandatory captive audience meetings are not lawful. NLRBs tend to change with different administrations, so we'll see if that changes. But for the time being, again, if you have any captive audience meetings, make sure that they are optional for your employees, make sure that they're being compensated for the time missed, and make sure that you're training your managers and your supervisors to know what they should and should not share at mandatory meetings with your employees. All right, we also have some updates to labor law posters. As you know, it's January. We just got through December. December, January is usually our labor law poster season. That's when we get those shiny new posters and replace the ones that are in the lunchroom or in the break room or whatever it is with the new ones with new information. So some of the changes we saw this year, we have AB 2299, which is the Whistleblower Protection Act poster. Um, this new this one was one of the ones that was updated. So again, if you do your updates yourself, make sure you get the most up-to-date poster for whistleblower protection. Minimum wage, of course. We mentioned minimum wage change in the state of California. So make sure you have the most up-to-date one with the right information. Same thing if you have in the fast food or healthcare industry, make sure you have the right supplemental poster with that information. The workers' comp information also changed this year, and there is, of course, a new poster for that. So basically, the new poster, new right, or the new guides basically gives information about the employee's rights to consult an attorney, and talks about in most cases those attorney's fees will be paid from the employee's recovery. So again, it's a updated DIR notice. Make sure you have the right one posted on there. And finally, the Civil Rights Department. They are very good about updating their posters on a regular basis, which is good for us, but also, of course, bad for us because we have to keep up and make sure we have the right one up there. So make sure you have the right discrimination and harassment poster, and as well as the right family care and medical leave and pregnancy disability leave posters as well. Now, if you want to avoid having to scramble around and look for all those posters yourself, just get one of those fancy schmancy all-in-one posters, which we have available again on employer.org. That is the all-in-one labor law poster, has all the postings you need. I believe it's English on one side, Spanish on the other for your convenience as well. So take a look on our site if you're still in the market for posters. have a lot of different options for you there. Now, if you ordered your poster back in December and you haven't received it yet, just make sure you hold on to your receipt or your proof that you ordered it before the end of the year. In case you get a visit from state agency, you can just present them with that. Say, hey, we're still waiting for it to arrive. Here's the proof that we ordered it. And that should suffice to keep you out of trouble, at least for the time being. So, a few reminders about your employee rights and to-dos. Again, take a look at the guidance on harassment on harassment in the workplace. The EEOC's new guidance and the new examples. Those are, again, 70 new examples, I believe. A lot of good information there. And remember, just because we see people doing it, whether it's, actors, politicians, influencers, whatever it is, does not mean it is legal or right. So again, make sure your employees understand your harassment and discrimination policy, understand what they should or should not be doing, and make sure that you stay up to date on that training, right? As you recall, all employees and supervisors have to go through harassment training, either 1 or 2 hours, depending on their position, every 2 years. So make sure once they're on that cycle, you stay on that. Make sure you have any new hires, you're also giving them that training in a timely basis, when you hire them on. Take a look at your handbook policies regarding protected classes. Make sure that your handbook policies and your harassment discrimination policies are up to date to include the new concept of intersectionality and to include all the protected classes as well. Unfortunately, we run across a lot of policies that we help with or that we see that were maybe put together 5, 6, 10 years ago and not touched since. There's a lot of information missing from them. So make sure you're taking a look at those handbook policies every year, at least once a year, to make sure they're up to date. Take a look at your job postings and applications, any other kind of material, job descriptions, again, to see if you are requiring a driver's license where it is not needed. Remember, asking or turning away candidates for not having a driver's license when it's not a requirement of the job can be a violation of that protection. So again, make sure if you're requiring a driver's license or posting that as a requirement, make sure it is truly, truly necessary. Now, when it comes to captive audience meetings laws, make sure we train our supervisors on them. Again, sometimes our supervisors have the best intentions. We know, a lot of times we work in politically charged climates and that sort of thing where maybe supervisors, owners, whatever it is, want to share their opinion about things that are going on or about proposed laws or whatever. Make sure you train your supervisors on the captive audience meeting law, what they should and should not be talking about, or what they should or should not be doing at mandatory meetings. Finally, labor law posters. Again, that's the biggie, right? Make sure we're updating those postings every year. Put it on your calendar. Once December starts rolling around, it's time to order the new ones. If you haven't ordered them for this year, now's the time to do it. A couple different options. You could get your paper copy or laminated copy. There's also some options for doing them online or on your company server if you are in a remote environment. So take a look to see what option works best for you, but make sure you have the most up-to-date one. And finally, a reminder, all our CA members have access to free harassment prevention training for their staff through CA University. So that's where they can go online, assign that training to employees. They'll get a link and they can do it online through that recording process and be compliant with that. So if you don't want to do it in a way where you get everybody in one room and have one presenter, if you're a CA member, you can just kind of assign it virtually to everybody individually. They could do it at their own pace, at their own time to stay compliant with you. So with that, that brings us to about the halfway point. I will stop sharing and see if there's any questions out there that we need to address.
I think you addressed most of them. If you want to speak a little more to the labor law poster, we did have somebody who asked about that. I think you were getting to it. If they don't have a central location or maybe they don't have a break room, you can always post it in a hallway.
Right.
And if you are in a remote environment, do you want to speak a little more to that?
Yeah,
We have
yeah,
those
absolutely.
options.
Absolutely. Yeah, there's the options. I mean, just it's really should be in a common area where employees can access it. So even if you don't have like a break room or a lunch room, put it in the back of the office, put it in the middle of the shop, whatever it is. If you have a bulletin board, you could post it. We also see this a lot in, say, the construction industry where you have a lot of different job sites. Remember, each one of those job sites should probably have their own poster there. So that should be part of it. I know it can get a little complicated if you have, multiple job sites throughout the state or a lot of travel. So you can either have the option of providing them with each with their own copy of the paper poster to put up, or if you want to go with the virtual option, you just have to be sure that employees can access that basically at any time, right? So you
Yeah.
can't just say, this is on the website, but the website's shut down from, 4 p.m. to whatever. You have to be sure that the employees can access it basically at their leisure so they can know their rights. So again, take a look at that, see the one that works for you. If you don't have break room or a lunchroom again, just look to see where your employees gather. Maybe by the time clock or other areas may be a good option for that.
Great. Thank you. Yeah. And then back to that PAGA information, that was so good. And I know we have our toolkit that provides a lot of assistance when it comes to that. And I know if you've been through a PAGA claim, they are painful to go through. So I encourage you to look up at that audit list, that packet that we have. It includes a 20-minute training for your supervisors. So that's always a good thing too, because sometimes we miss training those supervisors, like Eli said. So check that out. It includes that 20-minute training, which is sometimes all the supervisors need to just brush up on their wage and hour information.
Absolutely. Absolutely. And the question just came up about required training for supervisors. Make sure for the harassment training for supervisors, that is a 2-hour training, not the 1-hour one. They have to go through the 2-hour training if anybody that supervises that's in charge of other people basically has to go through that. So again, do that. And then if, we recommend that wage and hour training for supervisors as well to help them know what the responsibilities are and ultimately to help keep you out of trouble, hopefully.
Yeah. Thank you, Eli. As we all know, the supervisors are our front line. They are representing the company most of the time. It's not the HR folks or the owners. It's your line supervisors. They're the ones that say a lot, interview, talk a lot, approve or not approve things. And so we want to make sure they're the ones that are trained and know about these new laws. So as they come up, making sure that you're relaying that information that you have. So let's dive in here. We have a lot to do. Eli had some fun parts because he got to tell you about the good news on PAGA and how you can train on that. And so I'm going to review kind of more existing and old laws, but there's some good nuggets in there that you got to pay attention to still because we have some obligations as employers. So Eli's in the chat in the Q&A, so keep those questions coming. We love hearing from you. And if it's a more detailed question or more involved, always call into the hotline. That's what it's for, so that we can kind of run things by you. You can run them by us and we can ask more questions, more detailed questions. So let's get into crime victims leave. This is not a new law, but there's quite a bit of expansions that you need to be aware of. So just a month ago, the law was a little bit different. It lived in the labor code under section 230. So a little bit more about what our crime victims leave said was that we needed to provide employees with time off from work for jury service, witness duty, to sick relief if an employee was needing to get a temporary restraining order, for example, if they were a victim of crime or their child was. Employees could always use vacation and paid sick leave. As you remember, we had to change the paid sick leave requirement to allow employees to use that for crime victims as well, if they were a victim of any kind of sexual assault or stalking, domestic violence, and we amended our sick leave policy to include that. Well, we're going to have to amend it again a little bit, and we'll talk about that in a minute. We always had to provide reasonable accommodation to ensure safety at work, but that reasonable accommodation is going to be expanded a little bit too. Always had to maintain confidentiality. These are very delicate, serious issues and concerns when they come up. So always had to do that. So that's the old law. What is coming into effect now as of January 1st is there is a new definition of who a victim is. So we'll go over that new definition. And this is for all employers, by the way. That reasonable accommodation for the employee's safety at work is now extended to their family member. If their family member is the victim of domestic violence or they're a victim of crime, then your employee is supporting that family member, and we'll talk about who the family member is, then you need to extend those rights to them as well. So you need to accommodate your employee's schedule if they're supporting their family member through something like this. Employees can use paid sick leave for all crime victim purposes, meaning that you are also allowing them to use their sick leave if their family member is a victim of a crime and they are assisting them. You have to allow that sick leave for them as well. So we just continue to see paid sick leave being used for other purposes other than their own serious health condition. So look to that for that to continue, that kind of pattern to continue, and you'll see why in future slides here. There is a new notice requirement. That's another biggie, a change for AB 2499. So the employer must now provide a notice to new employees upon hire. So one more thing to add to our new hire orientation list is this new notice of crime victims leave. And then to all employees annually. This is about the only notice that we have to give employees annually if there's no other change to their status. So this is going to be a requirement from now on. And then also upon request, and at any time an employee informs you that they are a victim of crime or their family member is, you're going to have an obligation to give them their rights and responsibilities under that as well. And now, instead of living in the labor code, it's going to live in the Civil Rights Department. So the Civil Rights Department, as you know, is the same agency that tells us we need to train employees on harassment, discrimination. They handle a lot of different things, and now they will be handling crime victims leave as well. So the Civil Rights Department is going to be issuing the new notice. We don't have the notice yet, so that obligation to provide this notice begins once the Civil Rights Department posts that on their agency website. So once they have that available, which should be before July 1st of this year, we're anticipating it much sooner. Once we have that notice, then we will be posting it on our blog, letting our employers know, our members. So stay tuned with CEA. If you don't follow our blog, if you don't subscribe, I would encourage you to do so. It's free. You can subscribe to our newsletter. We blast our newsletter and blog whenever something like this changes and happens. So when we receive notice that notice has been posted to the CRD, we will let everyone know. So under AB 2499, what is this new definition of victim? Well, a victim is an individual against whom a qualifying act of violence, that's where the change came, has been committed. And so there's a variety of things. When before it was kind of limited, now it's expanded that definition. And if you have your crime victims leave policy in your handbook, which is recommended, then you need to include this additional protections for a victim, and when is there a qualifying act of violence. And then the family member, okay, so the family member is going to mirror that of CFRA or CFRA or California Family Rights Act. Who is an eligible family member? It is going to be the same people, and it's going to include a designated person as well. So someone who the employee designates as their person, they are included as well. So that is going to extend to them. A little bit more about this for employers who are 25 or more. So if you are a little bit bigger employer and have 25 or more employees within the year, then it used to be prior that you had to allow time off for work for reasons to seek medical or mental health, for them to do safety planning. Well, the changes bring about, again, more expanded, more reasons why an employee can take time off. And I'm sure you would probably doing some of this anyway, but we want to make sure not all employers were. So there are some expansions, and your policy needs to be amended to include this additional protections. So things like mental health services, safety planning, relocating, that wasn't included before, but if an employee needs to help a family member relocate their children to a new school, for example, if they need to provide childcare or even dependent adult care to ensure safety, all those things are part of this new law. You can limit the combined leave for all reasons to 12 weeks, and it does run concurrently with CFRA and FMLA. So if you have a situation where it is a domestic violence situation and the employee needs time off and they're also caring for it also qualifies as a CFRA leave, then you're running both leaves concurrently. And then the only good thing we have here with AB 2499 when it comes to supporting a family member, which is always a good thing, but when the employee's family member is the victim, you can actually limit the use to 10 days total, or 5 days if they're using it to relocate to a different school, something like that, or they're moving and the employee is assisting a family member, you can limit that to 5 days. So, we think this isn't going to happen, but it does arrive, and it's important that you train your supervisors because they're the ones that are probably going to be hearing about it. I actually got a call we get calls into the hotline, and it doesn't always seem like a crime victim leave, but it's usually an accommodation request or a schedule request, or an employee is acting out of character. I know we had a call into the hotline Hotline recently where an employer was saying that their employee was dealing with kind of acting different, unsure. They were having attendance issues, missing a lot of time. And when the supervisor probed the employee about it, it turns out that they were a victim of domestic violence and they were working on a restraining order against their abuser. So the employer then had to act on that information because they have an obligation under, again, the Crime Victims Leave to ask, did they need any support? And a lot of times the employer will say, look, it's none of my business. I don't need to ask, but you do. You need to inform that employee of their rights and responsibilities because they may not know that they have them. And so this was an example where we informed the employer, you need to at least give them that information and allow them to know that this Crime Victims Leave does may apply to them. And do they need help? Do they need assistance? And offer flexibility in schedule. In this case, the employee was asking for, thinking she was going to be written up because she had to attend court hearings. And so she wanted it to remain confidential, but she did disclose enough information for the employer to then accommodate a schedule. They actually ended up relocating her to a different location because this employer had multiple locations. So they relocated her temporarily to a different branch that the abuser didn't know about. They shared the picture of the abuser to the security detail, the security there, and kept it very confidential, but in a way where they were protecting their employee. So this is kind of the way it kind of creeps up into an employer's workplace, and we need to train our supervisors on their responsibility and how to react when something like this happens. So AB 2123, let's move on from crime victims to paid family leave benefit. One of the worst titles for something that isn't really what it is. So what is paid family leave? It's actually a wage replacement. I want to go on the record, Eli, to say I want to change it to paid family paycheck because that's what it is. It's a wage replacement. It is not a leave of absence. Paid family leave is something that the state provides as a wage replacement or as a paycheck. So it would save a lot of confusion if we drop the leave part, I think, because it is misleading. Employees think that they have a leave protection, but in fact, it's really just a wage replacement. So what it is it provides wage replacement when an employee needs to take time off to care for their family member or for bonding with a baby. So that's what paid family leave is for. That's what the employees are paying into on their paycheck, and it is allowed for them to take if it's used in conjunction with, for example, California Family Rights Act. If they have maybe a personal leave of absence policy at their work location, the employer grants the time off. The employee then goes and applies for this paid family leave. Well, it used to be the old rule that employers, we would require the employee to use 2 weeks of vacation or PTO before these paid family leave benefits kicked in. We would say there's a waiting period. The old rule was, hey, you got to use your vacation. We would force the use of that. Well, beginning January 1st, employers may no longer require employees to use that accrued vacation prior to collecting paid family leave benefits from the state. So if you should have a policy still that states that an employee shouldn't be going on unpaid status, so they must use their their vacation time when they're in unpaid status. We can't force the use of sick, but we can use the force the use of vacation unless it's prohibited. And this is a case where it is prohibited. So have a disclaimer that says we can force the use of vacation unless prohibited by state law, and this would be an opportunity where you couldn't do it, but nonetheless, it's good for other things. So this new rule applies to periods of disability beginning after January 1st, 2025. So we want you to update your handbooks because your old handbook may have said that we could always withhold or force you to use vacation time. So your handbook needs to be updated, your policies should be updated, and then also train your payroll staff that there are times when we cannot force the use of vacation time, and this is one of them. Okay, moving on a little bit, we're going to go into the retirement area. And if you have a retirement plan or a 401k plan, that's great, wonderful. You can probably tune me out for the next 30 seconds or so while I go over CalSavers. So CalSavers is for employers in California who do not have a retirement plan. State of California says we want employees to have a retirement plan. So if company, you don't offer it, then the state of California wants to tell your employees about this program. It's a savings program for employees in California California. And what you, employer, need to do is provide the state with the information, the employee roster, and then give them the information about CalSavers. And you should have, again, a policy on CalSavers that is a very generic one. You're not going to do too much about it. You're not going to encourage it or discourage it. You're just going to have a policy that says, hey, state of California has this CalSavers program. We're going to provide your information to them. California then sends them all this CalSavers information to see if they want to enroll. And if they do want to enroll, they're going to use you to withhold paychecks or make contributions through their payroll. So the employee participation is completely voluntary. They're just using you, employer, to get that information out. So the new law for 2025 is that the deadline has been reached for all employers of every size. It has been implemented little by little for employers, for California employers to tell and advertise this to their employees. And now every employer, whether you have one or more employee, has to register on the CalSavers website and start doing this plan. Again, this is only for employers who do not have a retirement plan. So all the other, and if again, your employees, participation is completely voluntary. By the way, while we're on the subject of retirement, if you have part-time employees, we just want to remind you that there is that the laws did change a few years ago, I believe in 2022, where your part-time employees may be eligible if they work enough hours in a year to participate in your 401k plan. So check with your brokers on that to see if some of your part-timer may qualify now. So in this section, as we round out this section, make sure that you update your crime victim and other affected policies and update that language on there. Prepare for new notice requirements. As we hear from the Civil Rights Department about this new notice, we will be informing you all about that. Update your leave practices in light of new rules about vacation and paid family leave, making sure that we're not forcing the use of vacation during that waiting time period for paid family leave. And then register for CalSavers. If you are a small employer that hasn't done that, now is the time to do that. If you need assistance with the handbook, just know that we do help employers with handbooks. If you're a member, you have access to purchasing that template very discounted. If you're not a member, you can still purchase our handbook template, and it's a very user-friendly template that you can go in and pretty much it's done for you. You just have to go in and personalize it with your information, and the template has instructions for you. So if you need assistance, either for us to do it for you, or if you want to download the handbook template, please visit our store, visit our handbook section. We also offer a lot of free resources, guys. So if you go to employers.org, you'll actually see some free resources there as well. Okay, so let's jump into the area of health and safety because safety first, right? We want to make sure that we're on top of our safety requirements and our obligations. So again, nothing really new in this area, but a lot of new things in July. So we want to mention them again and revisit them to ensure that you're in compliance. It's gotten to the point where we could really just have one person taking care of safety. It used to be we just added it to someone's plate, and I'm sure it's added to your plate wherever you are, wherever you're sitting today. But really, it's kind of becoming a full-time job with so many changes to our safety laws. Cal OSHA is very busy doing a lot of different changes. So the first thing we'll go over is the Workplace Violence Prevention Plan. This became in effect in July, as you remember. It says a new requirement to establish, implement, and maintain a written workplace violence prevention plan and update it each year, which is why we're bringing it up in the labor law update. We want to make sure that it's still on your radar. You didn't just do it in July and put it away, because it includes annual training requirements for your staff. So again, some of the key requirements for the Workplace Violence Prevention Plan is to create a written plan. That written plan template is available to you either on our website or on Cal OSHA's website. Cal OSHA provides that template for you, and again, you would go in and personalize it, very similar to your IIPP, to your COVID prevention plan, which we'll talk about soon. It's going to be something that you go in and download and create on your own. You can have help on this, but the requirement is that someone has knowledge of the work environment. So it really should be someone in the company who's working with someone, or that you're doing it on your own to create this plan. And part of that plan part of the information you write in this plan is that you've solicited your employees and that your employees gave you feedback. So you're going to want to do this annually again, where you're soliciting employee, and if you have a union involvement, you're going to ask questions. How can we keep this environment safer? You're going to ask questions like, has there been anything unsafe? What can we do to make the environment maybe, again, just ideas from the employees. They could come up with ideas. You need to show that you made that effort. And then whatever feedback you get, that you're going to connect that into the written plan. So you're going to have this annual training. In that training, you're going to review the written plan. You're going to talk about the feedback that you got from the soliciting when you ask them. And you're going to schedule periodic inspections, hazard corrections, these safety meetings. CEA has a wonderful template, also toolkit, that provides you with the templates for the inspection, the template for the hazard correction, the template for the safety meeting. So it's kind of nice. You don't only have to purchase it once, and it has all the information that you need. And it has a PowerPoint slide deck also that you can use for your training. It has all the requirements that you need, because there's very specific things you need to train your employees on. Certain definitions of workplace violence, what is all these key definitions that you have to know. So our slide deck already has them pre-populated for you. You would just go in and personalize it and present it to your staff. So that's an option for you. You have a requirement to investigate workplace violence incidents, and this includes like the example I gave you of the employee who was having an issue with the abusive conduct, domestic dispute. She was feeling like the person was going to possibly come into the workplace. When you have something like that happen, it's going to trigger your workplace violence prevention plan. It's going to trigger an investigation. It's going to trigger for you to do a record log of that incident. So that record keeping requirement for you to maintain a violent incident log is also something that is ongoing. So as incidents are reported, and again, this is where your supervisors need to know, if someone says, I had a little example here, if there's a disagreement over a project deadline and it leads one employee to shout to another employee saying things like, if you mess this up again, you'll regret it. There's no physical altercation there, but the threatening tone, the language could create fear and intimidation. And it may be an incident, probably is, because there was a threat, for you to document the incident, go over the workplace violence plan. And again, it becomes part of your log, the log that you need to maintain. So these are key requirements that are ongoing. We're reminding you of them because we didn't just do it in July and sweep it away. It's something that's ongoing. So again, schedule at least a review of your workplace violence prevention plan. Have you had any incidents that have occurred since July that we need to add and that we need to include? And then annual solicit employee feedback. If there was a broken window, a broken lock, what did we do to fix it? All those things need to be updated and show it as current. Annual employee training, do those periodic hazard inspections and those safety meetings. Once again, there's a bit.ly there. I'm sure Anna's on top of it, already put it in the chat, but there is a do-it-yourself workplace violence prevention package. There's different options in our store, the package, the training, a la carte. So anything that you need, we can support you in. Let's move on to the indoor heat illness. Also something, we were very busy. We're very hot and busy in July. And this indoor heat illness came into effect on July 23rd. And this applies to all employers in any workplace, but this one was kind of aimed and targeted at warehouses, manufacturing areas, restaurants with kitchen where it got really hot, but it impacts all employers. So any work area where the temperature reaches or exceeds 82 degrees while employees are present, which personally 82 degrees sounds good for me right now because I'm freezing. It's so cold in Southern California, but anyway, it's going to apply to those indoor places. So you do need to keep a gauge of what the temperature is and how it's rising. Remember, we always had the outdoor heat illness already. That is something that we always had to maintain. If you have workers working outside, we do have to have that outdoor heat illness prevention plan already. It is required to be written as well. CEA members, if you're a member with us, we do have a fact sheet if this is something that you want more detailed of. But what it includes are things like information on or having ability to have water for your employees, having an area in your workplace that is a cool down area. It could be someplace like a break room where it's going to be below that 82 degrees. So a cool down area, an emergency response procedure, a written plan of what you're going to do should the temperature rise to that level. I know it seems sort of silly when you're in an office setting, but you still need to have it done, and a plan in place to acclimate employees when the temperature, if you're having them work in an area like a warehouse or a kitchen where the temperature really gets hot. You have to have a plan in place, so that is also a template provided by Cal OSHA that you just need to go through and personalize. You need to train your employees and supervisors. So I'd say at the same time you're training on the workplace violence prevention, you're training on this topic as well, just reminding employees of this heat illness, or just pop it into your onboarding. Also, your new hire orientation, you can include it there as well. There is some additional high heat requirements when the temperature exceeds 87 degrees. So, or if they're wearing restrictive clothing, just know that if you're in that type of environment, do a little bit more investigating on the requirements for that, because your obligation's a little bit higher than other employers that maybe just have a general environment. Okay, our favorite topic, COVID. Not really. I never thought I'd see the day, but we've been counting down the days like I count down to my favorite concert. February 3rd, next week, it's when this goes away. So we finally made it, everybody. I think our next webinar that we do, this will be in the past, so this is fantastic. So Cal OSHA's COVID-19 emergency standard remains in effect through February 3rd. Now we still have to keep our records for COVID, any kind of positive cases. We had all those record requirements for another year, for February 3rd, 2026. But all those things that we had to do before, which by the way, you're still having to do it, having that COVID-19 plan, informing your employees of a COVID-19 case, telling your employers to stay out of the work area if they tested positive, all that goes away. There might be something new that comes into effect. You should continue to the compliance and monitor Cal OSHA's website for any changes. There is a bit.ly here that you should look into to see what's going to happen between now and February 3rd, if they're going to make something else. But it sounds like we're in the end stages here, and this is fantastic news. So this little COVID-19 little spiky guy is going to go away very soon, and we're all very happy to hear about that. To kind of just finalize the safety area here, if you are a work area that requires, maybe in the healthcare industry, that has their own workplace violence prevention plan because they've had their own, or you just need a little bit more support in this area, CEA has generic information for you, but we actually have partners that do this every day. This is what they do. So we are going to ask you to contact them. You can see there's 3 different partners that we recommend that you can work with should you need a little bit more help, if you need a little more hand-holding when it comes to training your staff on these important topics. Please reach out to them. So remember to comply with all this annually as we're entering this new year, that you're adding it to your to-do, that you have a date in mind when you're going to do this training for your employees, that you've developed your heat illness prevention plan, that you've incorporated into your onboarding so that you're training employees on that, and then monitor those COVID-19 requirements. Again, February 3rd is around the corner, but we'll just have yet to see if there's going to be any changes to that, because as we all know, Cal OSHA tends to do that at the last minute. So just going to say that, but crossing my fingers that we stay safe in that area. Okay, so we're kind of looking into the future as we end our webinar here as to some industry and employer-specific changes that may not apply to your workplace and your industry, but they tend to be something that we see happening in one industry and then expanding possibly to other industries. And they're usually a pretty good indicator of maybe what's to come in the near future for California. So the first one is SB 1105 that passed. It's for agricultural workers. It's a sick leave expansion. And it came pretty timely because of all the fires that we have been dealing with in California. So for agricultural employees specifically who work outside, they can now use paid sick leave to avoid smoke, heat, or flooding conditions created by a state or local emergency. And we all know believe we're still under emergency orders in certain counties and certain areas. So if you have agricultural workers working in that area, they can use paid sick leave to report to not when they're not at work due to these state or local emergencies. And once again, we're seeing that expansion of paid sick leave to be used for something other than sickness. So you want to make sure that we're paying attention to something like this, so that because it could again creep up and come up and be expanded to other industries. For now, Senate Bill 1105 is just for agricultural workers. If you're unsure if you have agricultural workers, I'd encourage you to look at wage orders 8, 13, or 14 to see if that's you. So for your paid sick leave policy, make sure you update that if you're an agricultural worker industry who has those workers, to include that they can now use the sick leave for those reasons. If you are in the construction industry, then AB 1034 is for you, and I applaud you for having a PAGA exemption. You've had it before and you continue to have it. Lucky you. And tell us the secret on how you all did that. I'm sure you had some really good lobbying people working for you. So this is for employees working in the construction industry. If they had a collective bargaining agreement, they were exempt from all those PAGA rules. All those PAGA claims cannot be made against this industry. And now that has been extended. AB 1034 has extended that to 2038. If you're unsure if your collective bargaining agreement has this specific requirement, if you're exempt, we're going to tell you to consult with legal counsel to see if you fall under this, if AB 1034 applies to you or not. Okay. So some local fair chance ordinances that I want to update you on. I know you're in Riverside County. There's some updates to LA and San Diego County, but once again, if we see it in our neighbors to our south and west, it might be coming to the whole state. So a little refresher, just in case you weren't sure what the fair chance ordinance is. This is for employers with 5 or more employees. You cannot inquire into criminal history. It's going to prohibit employers with 5 or more employees from inquiring at the interview process about their criminal history. So we know kind of the ban of the box, right? We can't ask about that until after a conditional employment offer is made. You have to make that offer first, and then you can inquire and ask a little bit more questions. And then if they say yes, and you happen to find out, or you do a background check, you cannot deny that employment unless you show a direct and adverse relationship. So even if something is flagged in that background check, you now have to show that there was a direct and adverse relationship with that after conducting an individualized assessment. So the state requires everyone with 5 or more employees, this is the state of the law right now, that individualized assessment is going to make you say whether or not this position, again, has that direct or adverse relationship. So I'm hiring a driver, they have a DUI, that's fresh on their record. Okay, there is a direct and adverse relationship, but something else may not have. So making that individualized assessment and rescinding an offer is a big deal. You rescind the offer, there's also other requirements that the state has us do. So make sure you're calling into the hotline, you're logging into our website to find out those templates that you need if you're going to deny employment. So the changes that's new for these went into effect at the end of the year, so we want to bring them up in the beginning of the year here. San Diego County, if you have any workers in there, their changes went into effect October 10th for the unincorporated areas of San Diego County. So again, those employers with 5 or more, they have the difference between the state law is that the individualized assessment must be in writing, where in the state didn't have to, although I think most of us are doing it in writing anyway, but it does need to be in writing, and it's going to apply to remote workers and contracts performed within those geographical boundaries. So making sure that we're very clear and careful on what we're writing down. So there's a website there if that impacts you. The LA County ordinance, very similar. That went into effect in the beginning of September for the unincorporated areas of LA. Unincorporated areas of LA is like crazy. Like there's certain areas that are, and the neighbor to their left is not, and the one to their south is. So if we're unclear, they provide a map, which isn't the best, but it is a map and a website where you can put in the street address and it'll tell you if it's an unincorporated area of LA. And this is enforced by the Department of Business and Consumer Affairs, so different enforcement agencies. And there are several differences from the state law with LA County. You do need to, there's requirements with the job ads, written offer letter disclosures. You have to have 2 written individualized assessments and record keeping requirements. And there is a new required notice to be posted. So you're going to want to log into this website that's here and that you can click on or copy and paste so that you can go into that ordinance and be careful about ensuring you're in compliance with that. So what's next for California employers? Again, ensure to stay up to date on those trainings that we mentioned before, that mandatory harassment prevention training. We at CEA just said we need to do it. This is our training year, I believe. That we're doing our annual workplace violence prevention training, that we're doing supervisor wage and hour training just to be preventative so that we can get on top of our PAGA so that we don't get hit with something like that. Or if we do, we can show our good faith effort in trying to comply with the law. Keep your employee handbook current with the new laws. Again, visit us or call us if you need assistance with that. Comply with the new wage requirements and pay attention to those local ordinances where employees are maybe traveling to and crossing the border into other states, making sure we know what those laws are. Ensure you have an updated labor law poster in your workplaces, wherever that may be, the workplace for that employee. Even if the employee only goes into the office a couple of times a year, if you have the poster there, that would satisfy the requirement. And then stay tuned to ongoing developments by following our blog. Again, we're nerds when it comes to employment law, so we stay on top of that stuff and we let you all know any kind of changes or updates to whatever's happening. And with the new presidential administration, I'm sure there's going to be some things. I just told Eli we might have a very active mid-year labor law update depending on how things go. So we've already gotten a lot of questions on immigration and I-9s and ICE. So we are doing that. Our blog is actually going to address some of those things soon. Our newsletter is going to address some of those things, or what are our responsibilities as employers and how do we react to that? I want to remind you of our complimentary HR hotline for employers for your county. Tell a friend, tell an employer friend in your county that we have this free hotline for them. And we love hearing from you. Eli and I are on phones weekly. So any kind of help, anything you need assistance with when it comes to this labor law update or anything that you might need that's HR related, please give us a call. If you need a little more support than the hotline, of course, we offer membership as well. And it's available on a monthly basis for as little as $125 a month or on an annual basis. And that's going to give you a little bit more support, more access to our website, where we're going to have things like templates and forms, fact sheets on a variety of topics, trainings, our CEA University that provides the harassment prevention training. And then depending on the level of membership, you may even have hours to use for training on site, where we can come in on site and do all kinds of compliance training, not just wage and hour, not just we could do wage and hour or leave of absence trainings, but not just the harassment. We also offer an HR Assist, where we come in and help you a little bit more of support. There's different plans that we offer for HR Assist for companies who want us to actually come on site or virtually and help with their HR department. We kind of, again, it's an assisting. We're not your HR person, but we are assisting your company with HR areas. So if this is something you're interested in, please make sure to download a flyer and visit us and inquire about this as well. And that's all I have. I know there were some things in the chat or maybe in the Q&A. Anything else to discuss? Otherwise, I'm going to give it to Anna.
Did everybody catch that? That was so much. I don't know how you cover all of that content. And yes, we did have 90 minutes together, but that is a lot. So we did wrap a couple minutes early. So if any of our attendees today have any final questions now that you've kind of been marinating on it for a little bit, this is your opportunity to get those answered. However, Astrid and Eli are always available with a number of our HR director colleagues to help you on that HR hotline. So if you don't think of it now, if you're like me, and as soon as you log off, you think of a question, go ahead and call that hotline. We'll be glad to help you. So as I mentioned, we do have a very brief survey. So again, you can choose your adventure if you'd like to snap the QR code on your phone. I know it's a little fuzzy, but I have tested it multiple times and I promise you it works. Or you can wait until you close out of Zoom. A browser window will pop up. All you have to do is click opt in. But it is a very brief survey, but we really appreciate your feedback so that we can really make sure that we are meeting your expectations with trainings like these. And if you are joining us for continuing education credits, I have your codes here. I'm going to drop them into the chat. I think we have a slide if it might be the next one. There it is. Cool, so your HRCI code 692931, your SHRM code 25-JSV5R. The SHRM code always makes me pay extra attention. And like our friend Eli says, whatever you do, don't forget the dash in the SHRM code. If you don't know what to do with these codes, you can email us ceainfo@employers.org or give us a call at your HR hotline. We will be more than happy to guide you on how to submit your codes for credit to make sure that you do get credit for joining us live here today. And so with that, I want to thank our trainers, Astrid and Eli, for sharing your time and your expertise with us, for answering all those awesome questions. Thank you for joining us live again during your lunch hour, and for providing us with a chance to answer your questions. And again, Jason, the entire team at the Riverside County Workforce Development Board, thank you guys so much for partnering with us to bring a series of trainings to employers like yourselves this year. And I do want to draw your attention, if you haven't been paying attention in the chat, if you scroll up a little bit, I did put the link to the next training into the chat. It's coming up on February 27th, and it's a very special one that we've formulated with their team. It's called Hiring Trends for 2025, Why Companies Should Support Skills-First Hiring. I had to make sure I read that to say it correctly. So that's going to be a very special training. We hope that you take advantage of joining us for that complimentary event. So with that, I want to say thank you and have a nice day, and we'll see you all in February. Thank you.